This is very, very important, and in my respectful submission, the answer, my lord, lies here. What happened to Jammu and Kashmir, its sovereignty, external, internal, my lord, the difficulty is the petitioners are confusing, in my understanding, internal sovereignty with autonomy. External sovereignty, my lord, nobody can dispute that it is with the Union of India. Internal sovereignty in the facts of our case and in the constitutional structure which we have accepted would mean autonomy of the federating units. And which autonomy is there with every state?
It's actually there with every institution.
Every institution is autonomous. So that's not internal.
We have the autonomous authority to decide a constitutional issue. So we can't say that internal sovereignty rests with us.
Yes.
We are an independent autonomous institution under the Constitution.
They are confusing the word autonomy with internal sovereignty. There is no internal sovereignty.
Except that, Mr. Solicitor, to paraphrase their argument fairly, what they are saying that, look, we gave up external sovereignty. There's no doubt about it. They say that we have acceded to the Indian Union. That's irrevocable. But they said that the course of events, the adoption of 370, would indicate that while there was a giving up of external sovereignty, a modicum of internal sovereignty, which was exercised by the then Maharaja, that was not ceded to the Indian Union. That seems to be the line of
submission. And my respectful
and therefore they are relying on various judgments of our court to indicate Indira Nehru Gandhi versus Rajnayan, to indicate that sovereignty has an external component, it has an internal component also.
Different context, but I'll assist your lordships on that.
By and by, in your turn, you can explain that line of. We are really on the list of dates. You can go ahead. Yes.
This is Mr. Shiv Singh.
Who were given, all of who were given.
Mr. Singh, let him continue. I mean, what's
this side patiently. No, when your side argued, there was no interruption from either the attorney or the solicitor.
Not many of them provided additional documents, additional judgments. We never objected.
These are well established. These are well known.
Why such sensitivity over some statement which comes because it may not be palatable.
So, Mr. Singh, Mr. Singh, equally we know that when we decide the matter, we have to give primary importance to primary sources, such as the statutes, the instruments of accession. These are other documents which he is relying on. The extent
Nurani was not even born when all this happened.
It's extract put in a list of dates.
I did object to Nurani. It's a one-sided picture.
Your nodal counsel argued that he received it Sunday evening. Your nodal counsel, he agreed in the morning that he received it long back, but he did not circulate it amongst you.
On Sunday, last Sunday.
There are extracts from a book in a list of dates. The book is not on record. It's not a document before your lordship.
We'll give more copies of the book.
That's not the point. I mean, this can just keep getting enlarged. I'm only saying that let's stick to the record.
If AG Nurani can be read, even a newspaper can be read. I'm sorry, I'm saying this with seriousness. I have read AG Nurani. It is a one-sided. But we didn't object for that.
That's all right. The Solicitor, you don't have to go that far.
No, my lord. I'm on page 40.
Mr. Singh, all that this really indicates, it's not like, conclusive evidentiary material.
Yes.
This is used to demonstrate that there were different points of view, different perspectives which were flowing in at that time.
A historical perspective of what people felt at that particular time.
There are several things mentioned by
dialogue that was taking place, where one side was expressing one view, the other side was strongly opposed to it. Ultimately, we have to interpret the provision of the Constitution and how this all came about. That's all that we are talking about.
You also referred to certain documents.
Fine, Mother, this going on, but I mean...
that's all right. These documents give us some air of the background, of different perspectives to the background.
Several new facts were stated. I didn't object because I didn't want to trivialize the dialogue. This is the Constitution bench we are at.
Please proceed.
This is beyond any instrument of accession or merger. This is accepting supremacy of our Constitution and surrendering the sovereignty to the Constitution, where the sovereign is we, the people of India. No.
Of course, when he made this proclamation on 25th of November 1949, this is on the same day as Dr. Ambedkar's last address to the Constituent Assembly, the famous address to the Constituent Assembly. So by this point of time, the entirety of the Constitution had been formulated.
Including 370.
Right? Including 370.
And Article 1.
Therefore, when he makes this proclamation, he makes this proclamation in the light of 370, which also is before him. Right? There can't be any doubt about that.
There cannot be any doubt. I bow down. And he is also very clear that what he is doing, at what stage and under what statute, what constitutional mechanism, which is temporarily provided. It was merely an act providing for internal governance of the state, which was an integral part of the sovereign, that is Indian dominion. But my respectful submission is that Constituent Assembly of Jammu and Kashmir, which formed subsequently, was not a plenary Constituent Assembly the way we had our Constituent Assembly, because by that time the sovereignty had already merged. There cannot be two constitutions. There cannot be, and therefore, my lord, I am saying that the sanctity of that document, which we call Constitution, is nothing more than an act of legislation, and I'll substantiate that. Apart from this,
Solicitor, this will require a little clarification.
yes, yes, my lord,
This will require a little clarification. At this stage, we are not saying anything, because when we talk about Article 370, including the explanation which is added, which is
separate submissions,
that will require clarification.
I'm conscious this is not the best point where I can justify the
We
substitution.
are not stopping you at this stage because you're going on facts.
This is not the best point on which, my lord, I would be able to justify substitution of a defunct Constituent Assembly with legislature. I'm not, my lord, joining issue with it. I have other set of submissions on that. At this stage, my lord, this is the perception, my lord, which I am presenting for your lordship's consideration. But the rest I can.
So, Mr. Solicitor, what we, as apropos what fell from Brother Justice Sanjeev Khanna, we are not engaging in a dialogue with you on any of these notes right now, because we take it that you will be arguing these aspects independently later on.
I just, my lord, brought.
So right now we'll run through the list of dates with you, so we have a broad drift of your analysis.
I just, my lord, point out
But
broadly.
we take it that you're going to take up each one of these strands later and argue them independently. Then we can, so instead of asking you any of our doubts right now, we'll reserve it to when you go into the themes themselves. Right now we can just run through the list of dates.
What I
Isn't it
intend,
better?
Lord, assisting your lordships, the way is this, my lord. After this, my lord, I'll show how the Constitution, how 370 worked till 2018, and some of the things are really shocking. And, my lord, I want your lordships, my lord, to know about, because practically, two constitutional organs, state government and the president, in consultation with each other, can amend any part of the Constitution the way they want and apply it to Jammu and Kashmir. For example, I'll elaborate on this. Please mark this. The preamble of Indian Constitution was made applicable to Jammu and Kashmir by way of a constitution order under Article 371B. In 1954. Thereafter, in 42nd and 44th Amendment, the word socialist and secular came to be added. That was not made applicable till 5th of August 2019. Jammu and Kashmir Constitution was not having either the term socialist or secular. And I will show, my lord, the devastating effect it would have, my lord, if this Constitution, which according to me is nothing more than a legislature, would not have been repealed the way, my lord, we have done. I'll explain the procedure which we have followed. I must satisfy your lordship's conscience. My lord, your lordships have very rightly flagged that ends may not justify the means, but I'll justify the means also. They are constitutionally permissible means.
Eventually, when you argue that this is really not a constituent assembly but a legislative assembly in its original form, you'll have to answer how this squares up with clause 2 of Article 370, which specifically says the Constituent Assembly formed for the purpose of framing the constitution of that state. That is because there's a textual answer which may militate against your line of approach on that.
Yes.
Anyway, we'll discuss that later on, because.
But please, my lord.
So in other words, Mr. Solicitor, to sort of paraphrase your submission, it's twofold. First, the expression of reservations in the instrument of accession was not unique to the instrument of accession, which was executed by Maharaja Hari Singh,
I couldn't put it that way.
to the execution of a merger agreement was not a sine qua non to be absorbed or become a part of the Indian Union. It's a two-fold.
Union of India.
We got the point.
There is no statutory source of merger agreements, and they were only signed in some cases as a result of negotiations between some states and Dominion of India. It seems, but it's more because of binding the princely state not to go back from its word that they were signed. It doesn't have any statutory source like instrument of accession. The country is one integral whole. Its people, a single people, living under a single imperium derived from a single source. This is the heart and soul of Article.
There is also a reference in his speech of 25th of November 1949.
Yes, for last closing.
The last speech. He said that our constitution is unique. It is federal at the same time unitary.
It is, it will come in the chronology.
This speech of Dr. Ambedkar also lays bare the distinction between a constituent assembly and parliament. At the bottom of that page.
Yes, but that was read by Mr. Sibal,
Yeah.
therefore I missed. I can go to that.
No, that's right.
But this was not read. I'm not repeating
Yes,
what was read.
Absolutely. Yes, absolutely.
Then 8849 is just an example how to retain your sovereignty. That is Bhutan. Bhutan has a treaty with us. Contemporaneously signed in 4750, that is 8849, where in external affairs, India has suzerainty. We don't have sovereignty. You can yourself realize the anomaly of the state becoming part of India and at the same time not recognizing any of these provisions. And I'll show till 76, Article 21 was not applicable in a truncated way. Article 19, there was a sub-article added as it applied to Jammu and Kashmir that the reasonable restrictions would be those which will be prescribed by the legislature, meaning thereby the persons against whom citizens invoke Article 19 would decide what would be the reasonable restrictions. I'll come to that. The question is very important. That why are you discriminating from people of one state and people of other? And your lordships would be shocked when I show the discrimination. We have analyzed, my lord, how the provisions were selectively picked up, modified and applied to one state. And I'm not saying that my power is taken away or state's power is taken away. So far, the residents of Jammu and Kashmir were being deprived of what I will show to your lordship. Till 5th of August 2009.